So hi everyone, thank you for joining us today. Thank you Rishi for speaking. It's great to have you. So Rishi Bandhu has advised and represented employers of all shapes and sizes across a variety of industries. In his practice at BLPC, he assists individuals and navigates their rights and obligations in employment relationships. He provides trusted advice to business owners, managers, and senior executives. Rishi advises and represents clients from a knowledge base that is rich, current, and informed by practicality and business value. He strives to provide the first-rate service in client communication. When necessary, Rishi is ready to litigate. He has appeared as an advocate in the Superior Court of Justice, the Ontario Labour Relations Board, the Ontario Human Rights Tribunal, and before labour arbitrators, with a strong record of success. Thanks again for speaking today, Rishi, and good luck with the presentation.
Thank you very much. It's a pleasure to speak on this topic. It's a tricky one, regardless of the side that you sit on, whether you're advising plaintiffs and or employers. I mean, what we do know is that employers and employees have obligations of good faith towards one another. For employees, I think the obligation is relatively easy to define and is largely limited to, I think, the obligation to maintain loyalty and fidelity and not to compete during the currency of the relationship, not to share competitive information, that sort of thing. I know a lot of management side lawyers want to expand the duty of good faith, especially the duty of honesty to employees, but the reality is that it for the most part applies to employers, and it's going to continue to do that. And the problem really is this power dynamic, right? So on the one hand, employers have the right to manage their business in the best interests of their enterprise, which means employees at the end of the day serve a business function. And that function needs to be eliminated sometimes. The difficulty, of course, is that this function is a person, right? And employees are dependent on their income. They're vulnerable to their employers. And, let's face it, human nature is such that where there's a power imbalance, there's abuses of it. So it's the good faith principle is a tricky balance, no doubt, because we're trying to balance the economic interests of the employer on one side and the vulnerability and dependence of the employee on the other, and it's not easy. Add to the fact that this concept of good faith itself is pretty amorphous, and violations can take a variety of forms. It's very difficult on paper when you're reading a case, when you're divorced sort of from context and hearing someone and looking them in the whites of the eye in terms of understanding what bad faith is, which makes it very difficult, as I mentioned, to advise both employees and employers. Nevertheless, the duty of good faith is here to stay, and it's continuing to evolve incrementally. And I think it's relatively certain that what that duty is going to look like a few years from now, it's going to be very different from what it is currently. So in the short-term time that I have with you, what I wanted to do is number one is look at the good faith duty of good faith in the manner of dismissal. As a legal concept, we're sort of comfortable with that now, but as I mentioned, very difficult to predict and advise. And we'll look at some key cases in that respect. Secondly, look at this concept of good faith as an organizing principle, which comes from the Supreme Court of Canada's decision in Bassine and in Herenu. And this is, in fact, where we're seeing the most significant evolution with the jurisprudence in a fairly short period of time, and where I think we're going to see even more evolution. And then related to that, we're going to take a look at two recent Supreme Court of Canada decisions. One is a very recent one from February involving Waste Tech and the city of Vancouver. And the second one from October of 2020 with Matthews and Ocean Nutrition. Two very significant decisions in my mind in terms of where this duty of good faith may be headed. So let's look at this duty in the context of the manner of dismissal. So it was originally formulated in 1997 in the Supreme Court of Canada's decision in Wallace and United Grain Growers. And at that point in time, the court said that, look, employers have an obligation to act in good faith in the manner of dismissal where employees are going to be especially vulnerable. In Wallace, the court rejected any sort of requirement that employers have to demonstrate a legitimate business justification for the dismissal. They recognize essentially that businesses need that flexibility to part ways with employees where there's a lack of fit without an excessive amount of scrutiny. So in Wallis, the court said that, look, where there is bad faith, where there is a breach of that duty to be reasonable, honest, forthright in the manner of dismissal, then judges are free to extend the notice period. So that sort of continued for over 10 years and led to a lot of arbitrary and unpredictable results with judges extending notice periods. And so the issue came back to the Supreme Court of Canada and Keys and Honda Canada. And at that point, the court said, look, we recognize that there's a duty of good faith in the manner of dismissal, but we're no longer going to extend notice periods. Instead, what we're going to do is we want judges to award moral damages for mental distress. So if an employer's conduct is in bad faith in the manner of termination, and that leads to mental distress that's reasonably foreseeable, then a trial judge, based on the principles of reasonable foreseeability, can award damages for mental distress. So now I think that the duty has evolved to a point where we've accepted that. I think that the decision in Keys has worked to a large extent. Trial judges now need evidence of mental distress in order to award moral damages for bad faith, but it's not necessarily going to be required in the form of any sort of hard medical evidence. And then finally, I think what's relatively clear now, and this is pretty significant, is that the duty of good faith in the manner of dismissal is independently actionable. So there can be an inability of a plaintiff to prove mental distress or to lead evidence of it, but nevertheless, that bad faith can form the basis of punitive damages. And we've seen that in one recent case with Morrison and Ergo Industrial Seating Systems. So as I mentioned a couple times, it's exceedingly difficult to predict damage awards. They range anywhere from $5,000 up to $250,000, and I've shown a couple of examples here. And again, when you look at this, it's really hard to understand or appreciate the circumstances in which these are awarded, because the facts seem pretty abstract, right? So if you take a look at the first example, $30,000 following a partial and scant investigation into unfounded allegations, not a lot of details in the trial decision about what that constitutes. So in today's context, where investigations are such a big part of the workplace and what's done, it's really hard to determine what constitutes a partial or a scant investigation that's going to warrant these types of moral damages. So there's still that uncertainty, but nevertheless, the damage awards are there and the concept exists. So moving now into sort of how the duty has evolved, the first real expansion of this concept of the duty of good faith was the Supreme Court of Canada's decision in Bassine in Herenu from 2014. Now, Bassine wasn't an employment case, but nevertheless, the decisions that have followed that have made it pretty clear that it applies in the employment context. So with Bassine, the court establishes as a general organizing principle in contract law an obligation to discharge contractual obligations honestly, reasonably, and in non-capricious, non-arbitrary manner. So again, it's an organizing principle and not a distinct implied term in each contract of employment or any contract for that matter. And the court was very clear about that. But what they do is they say, as an extension of that principle, we're going to import a duty of honesty. So in any contractual arrangement, parties can't lie to each other. They can't knowingly mislead each other about matters that are directly linked to the performance of the contract. So again, this general organizing principle is not an implied term, but it's a general doctrine of contract law that essentially imposes a minimum standard of performance. It operates irrespective of the intentions of the parties, and it is analogous to an equitable doctrine like unconscionability. Court is aware of the danger in creating these types of concepts and expanding ideas of good faith. They say specifically that it doesn't create some sort of concept of palm tree justice. And they're careful to point out, and they continue to be careful to point out, that this duty of good faith doesn't create fiduciary obligations or an obligation of duty to disclose, nor does it require a party to subordinate their interest to the other party or forego any sort of advantages under the contract. And so it's a concept in contract law, including employment law, that parties are free to breach a contract if it makes economic and commercial sense for it to do so. And we see that all the time in employment law, right? We see employers, sometimes we advise employers not to provide reasonable notice of termination in order to see if the employee is going to mitigate. And these are the types of behaviors that employers can still permissibly engage in without going offside of the principle of good faith. Where the restriction comes in is if the employer is acting in a dishonest way towards the employee. And we'll see in a couple of examples how that's come to be applied in the context of employment law. I think the first real significant application of Basine was Potter and New Brunswick Legal Aid Services Commission, and that was a decision from 2015. So briefly, the facts of that case were that Mr. Potter was the executive director of the New Brunswick Legal Aid Service Commission. He was on a 7-year fixed term of employment, and somewhere midway through that relationship, it becomes strained and the parties start to discuss a buyout of the fixed term arrangement. It doesn't go anywhere, so Mr. Potter commences a medical leave of absence in October of 2009, expecting to return to work in January the following year. Prior to that, the commission passes a resolution saying that he would be dismissed for cause if they don't resolve the buyout issue. They don't. Ultimately, they send a letter recommending dismissal for cause, and before that decision is made, the commission essentially suspends his employment and tells him not to return. He seeks clarification through his counsel, and none is provided. The commission simply remains silent and takes the position: look, we're still paying him. He's essentially on vacation. What's his issue? Right? We don't need to provide a reason if we're still paying. So he brings a constructive dismissal action and remains employed, and they proceed to terminate his employment. The significant issue in Potter was the reformulation of the test for constructive dismissal, and they established these two branches of the test. The first one was, in particular, is that if there's a breach, a unilateral change to the employment contract that's substantial in nature, that can support an action for constructive dismissal. And so what the Supreme Court of Canada says is, look, withholding work, whether it's with pay or without pay, can be a substantial breach depending on the circumstances. And in this case, they did find it was a substantial breach. And one of the reasons that they relied upon was that the commission gave no reason for the suspension. So they were asked what the suspension was about. They refused to give it. And relying on Basine, the Supreme Court said, being silent in those circumstances is not honest, it's not reasonable, candid, or forthright, which is exactly what Basine requires. And so that was used then, this organizing principle, to support the case for constructive dismissal. So as a result of Potter, we now have a very, very clear indication that, okay, Basine, which was in the context of a franchise relationship, clearly does apply in the employment relationship. Another significant application of Basine was Avalon Forest Sales and Evans. This was a resignation case. So essentially, 12-year employee had made an error. There was a difficult discussion with his boss about that. He ended up having a stress reaction and left. Comes back in the evening, drops off his keys, and says, "I'm done." Right. So there's an indicator that he's resigning, and as you probably know, a resignation has to be clear, unequivocal, unambiguous, and voluntary. And so what the trial judge said in those circumstances is that wasn't a voluntary resignation, number one, but number two, the employer, because of its obligation of good faith, needed to give that employee a cooling off period, and not capitalize on the resignation in order to serve its own interests. And so the decision went to the Court of Appeal. The Court of Appeal found that the trial judge had made an error in saying that the Basine principle formed a implied term and condition, but nevertheless did say that as an organizing principle, employers need to keep that in mind, so that if there's a resignation in the heat of the moment, their obligation of good faith and reasonableness and honesty would require them to hold off and not capitalize on that resignation and give that employee a period of time to cool off. Another interesting decision was from the Ontario Court of Appeal in 2018, Mohammed and Information Systems Architects. This concerned an independent contractor arrangement. So ISA was the contracting party. They had a contract with Canadian Tire to provide information technology services. They hired an individual to perform these services. As part of the contract with Canadian Tire, the individual that they assigned needed to be free of any sort of criminal record. So Mr. Mohammed discloses to ISA before the assignment that he has this criminal record. It was weapons related, dating back to high school. Who hasn't done something stupid in high school, of course? In any event, ISA says that's fine, start anyways. So he starts, he consents to a background check. The criminal record is disclosed to Canadian Tire, and Canadian Tire asks ISA to remove the plaintiff from the assignment. Now, the independent contractor agreement gave ISA a broad right to terminate the relationship for a lack of fit, and that's exactly what they did. They exercised that discretion. They terminated the relationship without any notice, and Mr. Mohammed challenged it. And was successful in arguing that contract couldn't be terminated without notice. And the court accepted that although ISA in these circumstances had an unfettered right to terminate the contract, and it could terminate it in its discretion, it had an obligation to do so in good faith and to only terminate that contract in good faith. And so in these circumstances, simply taking the position that we're going to terminate this relationship without any notice whatsoever, because they had the discretion to do so, was in bad faith. Now, related to that is the more recent Supreme Court of Canada decision in Wastech in Greater Vancouver. This was just released on February 5th, 2021. And this case is significant because the court gives more guidelines about how discretion is to be exercised in the context of a contractual arrangement. So Wastech is not strictly or not at all an employment decision, but nevertheless, I think we can see that there could be some application to discretionary decisions in the context of an employment relationship. So very briefly, Wastech had a contract with Greater Vancouver to transport waste to one of three disposal sites. Now, Metro, the Greater Vancouver, their right was to direct which disposal site was to be used in their sole discretion. One of these sites was further away from Metro, and it ate into their profit margins. So in 2011, Metro exercised its discretion to allocate waste to the furthest site, and Waste Tech says that's unfair. There's an arbitration clause. Arbitrator finds that Metro's discretion was not exercised in good faith, overturned on appeal, and that appellate decision is then confirmed at the Supreme Court of Canada. So the Supreme Court confirmed that there was no breach of the duty to act in good faith in these circumstances, and then clarifies the parameters of the duty to exercise discretion. And these are some of the things that they said. So there is an implied duty to exercise discretion in good faith. At a minimum, that discretionary power has to be exercised honestly and reasonably. It can't be exercised in a capricious or arbitrary manner. But what the court isn't going to do, and going back to this idea that they don't want judges dispensing palm tree justice, they're not going to question whether or not discretion is exercised in a morally opportune or wise fashion from a business perspective. And finally, the loss of a benefit is not determinative at the end of the day in terms of whether or not a decision has been exercised in bad faith. So Waste Tech, from my perspective, is significant, and we see discretion being exercised all the time. And I think one potential application of this idea is with respect to promotions in the non-unionized environment. If individuals, for example, are employed for a considerably long period of time in a certain position, an opportunity arises and then they're passed over for someone outside of that organization, I think Waste Tech and Basine opens up a window for that employee to say, look, the discretion to pass me over was not exercised in good faith. So not necessarily discriminatory in the sense that there's a human rights violation, but if there's personal animosity or if the reason is frivolous and arbitrary, it gives an opportunity to challenge that exercise of discretion. So one of the interesting that arises out of the Supreme Court of Canada's decision in Matthews and Ocean Nutrition is this idea of a non-monetary benefit of work. And so Justice Kasser in Matthews talks about this benefit in Obiter, but suggests it's something that courts will apply and maybe be receptive to arguments in the future. So let's talk about Matthews a little bit. So again, it's an October 2020 decision. Mr. Matthews is employed as a chemist and a senior manager with Ocean's Nutrition from 1997 to 2007. In 2007, there's a new COO. He doesn't like Mr. Matthews, so he tries to marginalize him and lies to him about his future in the company. And the trial judge accepts on appeal. It's accepted that the COO was dishonest. He endures this treatment for a number of years and then decides to resign in 2011 to accept new employment. And 13 months later, Ocean is sold for $540 million. If Mr. Matthews had stayed with Ocean, he would have received a $1 million LTIP bonus as a result of the sale. So not surprisingly, Mr. Matthews says, I'm going to sue for constructive dismissal. He does so. The trial judge awards a 15-month notice period. Because the LTIP bonus falls within that period, trial judge finds that he is entitled to it. Ocean's appeals that decision, and the Court of Appeal allows the appeal, saying that the bonus language foreclosed any entitlement to the LTIP. Now, interestingly, at trial and at the Court of Appeal, bad faith was not part of the analysis for compensation. The trial judge said he's awarding the bonus because it fell within the reasonable notice period, and the Nova Scotia Court of Appeal allows the appeal on the basis that the bonus language excluded it. So Mr. Matthew appeals, goes to the Supreme Court of Canada. He argues there that the LTIP entitlement flows potentially from two sources. Number one, Ocean's failure to act in good faith and their breach of this obligation to act honestly in accordance with Basine. And as a result of that breach, it's a foreseeable loss that he would lose out on the LTIP, and therefore it should be paid to him. And in the alternative, and consistent with what the trial judge said, the LTIP should be awarded as damages in lieu of notice. So the Supreme Court confirms the employer's obligation to act good faith in the manner of dismissal and not to lie or knowingly mislead employees, but takes the easy way out to some extent by saying that the LTIP bonus was grounded in reasonable notice principles and not good faith. And it does so for a couple of reasons. Number one, the trial judge at the time didn't have the benefit of Basine, and the pleadings in the evidentiary record were deficient in terms of mental distress and the effects of the bad faith. What Mr. Matthews' counsel tried to do was encourage the court to adopt this overriding generalized duty of good faith performance that animates the entire employment relationship, which is exactly what the court said in Wallace it would not do. In the end, Justice Kasserer doesn't do so, but seems to be receptive to the concept. And he recognizes that in employment relationships, there is this non-monetary benefits that employees derive from employment. And that non-monetary benefit, he says, can be wrongly taken from employees if at the time of dismissal they're lied to or misled as to the reasons for termination. And then he goes on to say that it may be that a duty of good faith will one day bind the employer based on a mutual obligation of loyalty in a non-fiduciary sense during the life of the employment contract, owed reciprocally by both the employer and the employee. I recognize, however, that whether the law should recognize this is a matter of fair debate. So he doesn't go so far as to recognize it, but does seem to leave that window open to recognize in future cases. So that's a very brief history and a very brief overview of the evolution of the duty of good faith. What's clear is that it is here to stay. We've had a very rapid evolution of this Basine concept, I think, from 2014 up until now, right through to WASCO from February. And I think we're going to continue to see an ongoing evolution of that. Given Basine, Potter, Matthews, and now Wastech, we may see this original restriction that we saw in Wallace about bad faith discharge not existing. That may be evaporating to some extent, and creative plaintiff counsel may be able to make some headway going forward with challenging decisions to terminate that are in bad faith. And that's all I have. Thank you very much for listening.
Hi, Rishi. Can you hear me?
I can.
Hi, yeah, I just want to come on and say thanks for your presentation. It was really good, excellent, really well done. We do just have one quick question here from Tony. So he asks, can we have a copy of the session and the PowerPoint slides?
Yeah, absolutely. If you want to reach out to me by email, Rishi at BLPC, I'd be happy to send it to you.
Awesome, great. Well, thanks again. This was a really great presentation. It's always great. It's great to have you speaking today. Just to let everyone know, so our next round of sessions actually begin in about 1 minute, 3 o'clock. So that's going to be Jordan Rodney, excuse me. But yeah, thanks again, Rishi. It's always great to have you speak.
Thank you very much. I really
Bye.
appreciate the opportunity to speak.